Counsel, you may proceed.
Good evening, Your Honor. My name is Diana Ruiz, and I'm the pretrial attorney for the prosecution in People v. Fromholz. The prosecution requests that Exhibit A be entered into evidence based upon the totality of circumstances available to Detective Sachs, which indicated that Alden Mitchell had authority to consent to the search of defendant Fromholz's laptop. There are two kinds of third-party authority: actual authority and apparent authority. Apparent authority can be enhanced by the totality of circumstances, which are all the facts available to searching officers at the time of the search. If neither authority is present, then there is no authority for a third party to give consent to a search, as in Truelove v. Free, 275, Fed 3rd at 391. I will be giving the court a brief explanation of actual authority. However, due to time constraints, I will be focusing on apparent authority and the totality of circumstances that validated Mitchell's authority. Actual authority is present when a third party, such as Mitchell, possesses common authority over the place or item to be searched, such as the common area within the shared hotel suite between Alden and the defendant. In the appellate court case of United States v. Kimawana, 383, Fed 3rd at 1215, the court considered the facts available to the officers at the time of the search to be sufficient to commence a search without a search warrant. Officers were aware that the third party carried a key to the hotel room, had spent the night in the hotel room, and had left possessions in the hotel room, all of which signaled third-party common authority and thus actual authority to consent to a search. Apparent authority is present under three elements. 1. Visual indicators of third-party authority to consent, such as the mutual use of a space or particular container. 2. Whether officers were told incomplete or untrue information. And 3. When faced with an ambiguity, officers acted with reasonable caution and further inquired about third-party authority to consent, as seen in United States v. Andrews, 483, Fed 3rd at 711. During Detective Sachs' search, all three elements were present. In our case, Mitchell's actual authority evaporated at the door to the defendant's room because Mitchell did not have the sole use or control over the defendant's room. From then on, Mitchell had apparent authority. That apparent authority extends to Mitchell opening the defendant's room, the door to the defendant's room, opening the defendant's computer, turning the power on, and displaying the defendant's desktop user account on the screen. If you view the logging in process, Mitchell's authority is still apparent because there's nothing to tell Sachs that Mitchell's apparent authority has evaporated. Courts must consider what facts and circumstances searching officers know at the time of the search. Nothing in the facts indicate that Sachs knew or should have known that the defendant's computer password had been changed. In United States v. Buckner, the totality of circumstances provided officers with the basis for an objectively reasonable belief that Michelle, the third party, had authority to consent to a search of the defendant's computer hard drive. In People v. Fromholz, Sachs had an objectively reasonable belief that Mitchell had authority to consent to a search of the defendant's desktop. In United States v. Buckner, the court concluded that Michelle, the defendant's wife and cohabitant, possessed apparent authority to consent to a search of the defendant's computer. There are similarities between the facts of People v. Fromholz and United States v. Buckner. While the two cases are not identical, the similarities are significant. In Fromholz, Mitchell told Sachs that Mitchell occasionally used the defendant's computer. In Buckner, Michelle told officers that she occasionally used the computer to play solitaire. In Fromholz, Mitchell told Detective Sachs that Mitchell could get into the defendant's computer. In Buckner, officers observed that the computer was turned on with its screen contents in plain view. In Fromholz, Mitchell did not tell Sachs that the defendant had changed their computer password. In Buckner, Michelle was unaware that the computer was password protected. In Fromholz, Sachs took a picture of the defendant's desktop screen but did not open any files. In Buckner, the officers made a copy of the defendant's hard drive but did not open any files. In Fromholz, the defendant believed that he was the only person who knew the password necessary to sign on to the laptop. In Buckner, the defendant believed that he was the only person who could sign on to the computer and the only person who knew the password necessary to view the files he had created. In Buckner, officers made a copy. While it's clear that Michelle had at least apparent authority to consent to a search of the computer, the totality of circumstances make Michelle's authority to consent even stronger. Detective Sachs is taking Detective Sachs taking a photograph of the defendant's desktop is analogous to making a copy of the computer hard drive, as searching officers were simply saving information for later review. Once again, Your Honor, the prosecution requests that Exhibit A be entered into evidence in the trial. The defendant's Fourth Amendment rights were not violated at any point during Detective Sachs' search. The totality of circumstances support Mitchell's apparent authority to consent to a search of the defendant's computer.